Good morning. I'm Steve Levitsky, Director of Dr. Class, David Rockefeller Center for Latin American Study. I would like to welcome you to the third session of our academic forum for the new constitution in Chile. The headline is Can we close the gap for social demand? And the process is being observed closely all over the world. The Chilean process is not just offering some possible uh, way out of the crisis that Chile is showing, but also the possibility of building a more inclusive system, more representation, and the fate of this process in Chile will have some echo beyond the Chilean borders. In Dr. Class, we think that Chile could become a model of constitutional reform in the 21st century, and we think this process could become a source of innovation. Will be providing lessons for other countries, not just in Latin America, but in the North, like it in the United States, a country that seriously requires a constitutional reform. So during the whole constitutional process in Chile, the forum will attempt to be the platform for an open debate about the problems and the dilemma of the Chilean people about rewriting their constitution. Also, that will be for Chile and the rest of Latin America and the United States to talk about the important subject matters of different political views and ideologies. The two sessions to come will be on May the 7th about the rules of the game in the new assembly. That is just a possible headline. How would you be interested in this and you know yet? And the other will be on June the 18th about how the new constitution could affect Chilean economy. Also, the headline could be varieties of the conclusions in capitalism. Before we could kick off, I thank you, Dr. Klaas, for the regional office in Chile, the official sponsor of this meeting. Thanks especially to the director, the maximum head of this office in Chile, Marcela Renteria, who created this forum. I want to thank you, our consultative committee, Veronica Figueroa, a scholar in Harvard in the Public Studies Institute, Claudio Fuentes from Diego Portales, Claudia Hayes, Universidad de Chile, Juan Pablo Luna, Sol Serrano, Sebastián Soto, all from Universidad Católica, Christian Rodriguez, associated to Dr. Class this year, and finally Manuel also from Harvard Association of Students, and Luxus Scholar Foundation for their support. And I would like to thank our excellent panel members, the local ones and the international ones. The moderator, Mr. Sebastian Soto, professor of constitutional law and the director of the Department of Public Law in the Department of Law at Universidad Católica de Chile. He studied at Universidad de Chile and Columbia University in the United States. He has been Dr. Klaus Luxich Business Scholar in 2013 and 2014, and he is the author of the book The Time of the Reconstitution, One Day for the Convention, Universidad Católica Editions. Sebastián, the floor is yours. Thank you very much, Steve. Thank you, Dr. Klaas, Rockefeller Center for Latin American Studies from Harvard, and the Academic Forum for the new Constitution for this stimulating task I've been assigned, which is being the moderator of this deep and interesting panel about the constitutional change and social demands, which attempts to give an answer to the question, can we really close the gap? We are with four academic members of different faculties from Chile and the United States. And the way we will use is as we have done in previous seminars. First, we will open the presentation with Daniel Brinks, and then Rosana Castiglione, Yanira Zúñiga, and Marisol Peña in that same order. They will have a reaction with comments and analysis of what has been talked. After that, we will open up a set of questions and answers that you could already start creating in the Q&A below in the Zoom application, and I will be redirecting them to the different panel members. On this, we will be approximately 90 minutes, 1 hour and a half, up to 1:30. But then we will open a space that Dr. Class webinars have characterized gathering the people who is in the Zoom meeting that could stay beyond 1:30 to talk in a non-formal way among all of us for 20 additional minutes. So after 1:30, if you want to stay, you will get you will be allowed into the Zoom, and we will open the conversation in a direct way and without formal requirements. So not much to say. I will introduce our panel member. The main panel member is Daniel Brinks, Professor of Government and Law and Chair of the Government Department at the University of Texas, Austin, who received a PhD in Political Science in Notre Dame University and in Michigan. He is a consultant in Latin American Studies and Human Rights in the Faculty of Law with comparison of politics, policies, and democratization in Latin America. The research has been in court and law, and a book that he recently has is The DNA of Constitutional Justice in Latin American Politics, Governance, and Judiciary Design. A book in English with several awards like Herman Pritchard on the best book on law in court and American Political Science Association award. Not much to say. We welcome Daniel, and you have 15 minutes to give us your reflections. Thank you, Sebastian. Thank you, Steve Levitsky and Dr. Class, David Rockefeller Center for Latin American Studies, Sebastian Marcela Renteria, for all the work you have been doing to organize this forum that I think it's so important. And especially thank you, Yanira Zúñiga, Marisol Peña, and Rosana Castiglioni, who will be answering. I always learn a lot about these events and these exchange, so I'm really anxious to receive this conversation. The headline we have given is an important question, really admitting two opposite answers depending on how we interpret that and what we expect from constitutional change. If the question is, can constitutional change close the gap between their reality and social demands? Then the answer is obvious no, you can't, because no text on its own will do a thing. And I will say more. And second, because social demands, especially the ones that we see in Chile, are ambitious, looking for a deep transformation and radical that is hard and costly for any political system. The society asks for more, and we are asking in the short term and medium term. And the texts promise, the books promise something that we have never been in a system observing. So, more than closing the gap, constitutions aim to that gap. They give it a name and they make that obvious. If that is the question, can we really solve all the social demands with just constitutional change? Then the answer is obvious. No, we can't. We can't do that. Even constitutional change that is promising transformation could be dangerous. It could even arrive to a cynic position, and losing the change on democratic ideas. So we need a more realistic appreciation of what we can do in a constitutional change. That's one point on that side. But if the question is, can this constitutional change be just one element and important of a broad institutional transformation of a political and social movement, contributing to closing the gap, providing more tools to the social groups, to the political movement, to the individual citizens, so they could contribute to define a new social, economic, and political reality in Chile? Then the answer is yes. I think that constitutional change could be part of the scaffolding of a new political and social reality to contribute to the change and to close that gap between the demands and the reality. Well, first, all in all, we have to have an idea what a constitutional system could do and a justice or constitutional justice system could do, its possibilities, and also the limitations of the constitutional side. We could focus on what we think it's the hard core or center of the social constitutionalism in right, in law, in justice, in the constitutional courts, sometimes in um, constitutionalisms, not just because they are the most important, but they are the more skeptical side. So the question is, what is the value of a long list of rights? How can we demand that through law, the um, individual and strategic, maybe judicialization of policy, maybe on the constitutionalization of the social demands? Social demands in Chile, and many of you know better, look for more social inclusion, economic and political. Many of the demands have a voice in the cultural, social, and economic rights that we call desk, looking for protection for elderly people to have access to health, right to water, a system of education that is reachable, and more equality in the economies, including sexual minorities and lots of subjects. We could even recognize the First Nations. So we see some signs that say dignity, more dignity in the life of citizens. So it's a whole series of things. And I agree that the constitutional change is one of the necessary elements in Chile for these social demands. But the question is, what is the best constitutional model to take Chile closer to these objectives? The current chart is a problem that we know very well, and I know there's a debate on that, but it is convincing to me what Fernando Atria calls in the analysis of the tricky constitution with some traps that have been an obstacle for more inclusion in Chile, being deceitful. I was in a panel with this constitutional expert from Chile, and he said what we need for a new constitution to be written is not a pencil, but some eraser. So that is a possible model. We will require a constitution with less traps or blocks, with a scaffold, constitutionally speaking, that allows the people in Chile to act democratically with the voice of the majority without hindrances that are for minorities to build a new Chilean reality to the like of the majority. And that is a point of view that is quite respectful, and we broadly share that in the constitutional experts in Chile and the world, especially in the Anglo-Saxon and European world where constitution is reduced, and that is the model and the standard of the norm. But in the South, in the global South, the model is quite different. The demand for a house with dignity, health, work, and labor conditions protected, when you're old are part of the Constitution and also subject to be in a litigation. Our demands are demanded rights, and it's a matter of litigation if necessary. The social demands are broad, ambitious, and they are not part of the regular politics, but they are under the constitutional justice umbrella. So the question is, what is the difference of presenting the state a demand that is part of the daily politics and the other that is on the axis of constitutional? And I can differ with the lawyers and the constitutionalists. I think I think that the difference between one and the other is not as so many imagine a categoric thing. The difference between law on one side, the public law, the constitutional law, and politics on the other. And that does not imply, as you might think, a warranty of realization through the dark side of the law. I am entitled to labor, then I will have a job. And finally, and maybe it's the most important, to include something in the sphere of constitutional justice is not taking that subject out of the daily politics. All on the contrary, if we put something on that place, that means adding an additional layer of strategies and political resources and institutional resources to what we already have in our daily politics strategies and resources that, of course, are to our reach, not just the progressists or the ones that are right or the ones that we like more. And it's so true that in the space of the daily politics, government coalitions could act without being accountable to any others than the constituents. It is more from the majority in the daily politics. But as you know, the problems with Constitution of Pinochet in 1981, you know the pathology of the daily politics that has been subject to social demand. It's not a romantic thing of constitutionalism and the daily politics in any country that wants to define the options and possibility for the daily politics is the representation, the political parties, lobbyists, activists, the political elite, and being accountable to the people is an episode is in retrospective and it's from the elections. So that's what we all know as the democracy. In the space of constitutional justice, where we see the court subjects the economic and social rights, especially when they are part of a litigation, the government coalition and the majority acts, maybe most of the times the first to act, but the minorities also have their constitutional claims and the organized civil society also act. The main speakers are the representatives that will articulate the social demand first, but also you have the lawyers, the judges, the constitutionalists. So the spaces of key decisions are the legislatures, where you first have the public policy for, let's say, education, health, whatever, but also the court makes decisions to review the actions or the omissions of the legislature and the executive branch. So, in the space of constitutional arena, these are the first actors, the ones to start the movement, or by omission, the ones that wouldn't do a thing, but in fact, they're not the ones with the final word. Being accountable on elections is not something that disappears in constitutional justice. Many times, it is the judiciary intervention that triggers the electoral dynamic. And empirical literature says that the electoral dynamics is the one that will empower the judiciary response. So, in the umbrella of constitutional justice, is not that void of the politics, but a more dense politics space with multiple discourses, multiple standard and norms, more stakeholders, more main characters that would provide the DESCs more accountability. In that space, when you have an unfulfilled promise in text, that will become the frustration of the citizens, will become political and judicial weapons. There's no any guarantee, and the rule of law above the politics. We could even talk more, but there's a new space, a new opportunity to complain about the state of attention to subject matters that are part of constitutional rights. So these are decisions that could be a dialogue that is complex. The representatives, the judges, political elites, the public, and the organized civil society. Constitutionalizing means adding stakeholders, institutional spaces, discourses, and logics. Then we go back to the initial question. I know I have very little time left. Can we, in the constitutional change, close the gap between the social demands and the economic and political and social reality? Well, in a way, yes. In a way, no. It's not the constitutional change in itself and the promise on something that is written, the one that closes the gap. But what that change means, that change first means a social movement looking for expansion on the ends of the state, expanding the institutional possibilities to present the demands in front of the state, and a policy that will have shown so many difference. And eventually, when you need to be accountable, that social movement will be in charge of doing the work, political work, of building a new state. They are the ones using the tools of the new constitution to build a new political space in Chile. That political space is not just going to be able, but wants to be able to give an answer to the social demand. In that work, then I think constitutional change could become an ally to bring tools and strategies, and even to foster insatisfaction with the reality that will bring us a more powerful social moment and more efficient. Thank you, Daniel, for these great reflections. I will highlight what the constitutionalists forget, which is this view of political science, politics itself, discussion, that is basically judicial, integrating the disciplines, multidisciplines of the discussion that becomes the objective of the academic forum of Dr. Class. So thank you very much. And now it is the moment for our three excellent speakers that will make comments and reflections on what you just mentioned, Dan.
The first in taking the floor is Rosana Castiglioni. She's a dean of the social sciences and history in Diego Portales University, also sociologist from the University of Uruguay, doctor in political sciences in Notre Dame, the US, and director of the Journal of Politics in Latin America. She's not only been professor in Rockefeller's Center in Kellogg, in Oxford, and other universities. Her work has been published in different academic magazines. She teaches compared social policy in Latin America and all the subjects that are key subjects nowadays. Rosana, the floor is yours. Thank you, Sebastian. Thank you, Marcella and Steve, for your invitation. I will focus in two aspects on Dan's presentation. And it's ideal to go towards a constitution and the overflow of demands that could be considered too much. And as Dan was saying, this allows us to see the glass half empty or half full. And this has to do with the possibility of this constitutional process, what it gives us in terms of achieving a text that has legitimacy, because this is not so in Chile. This is conceived in sin. And this is a constitution that was elaborated at a closed door process without democracy, without a decision-making process, and that could go against legitimacy of the text itself. And what we know in terms of political psychology is that when people perceive that the decision-making processes are made in open context, fair context, results are seen as legitimate, even though these results could be prejudicial to those that adhere or that give legitimacy to the process. There are many studies on terrorism emergencies that show that even in extreme crisis processes, these legitimacy processes are key for the results. So this is the good news. This is the news in our process. And if this constitution emerges, the new constitution emerges, it should have a greater legitimacy, at least for a broad spectrum of the population in Chile. A negative side, or the half empty glass, is linked to an overflow of the system in terms of satisfying the demands. And this is also linked to another problem that is a practical issue, which is the difficulty of construction of agreements that are probable and that are there in the process that we see coming. What the social unrest produced is a distance, a very strong distance in terms of expectation and reality. And that modernization process and in the introduction of the credit with the support of the state, it was that a full generation was able to go into the university, to attend the university, 70% of the students. And this came with an increase of the expectations in the future. However, there was a capacity of the system that was highly limited. It could not satisfy or meet the expectations. So what the theory of when we have a gap of privatization, when we have expectation and reality gap in between, so what is the unacceptable or the unacceptable gap emerges, citizens have a greater difficulty to feel satisfied. And this is what happened in Chile. And my concern is that the constitutional process will increase that gap between expectations and reality. So when we saw what were the demands during social unrest, any spectator would say that this is completely heterogeneous. And a picture that I take in my present in the I said new constitution, respect for transgenders, and for justice, abortion, equality, and we would see more demands if the poster was larger. And this is our 30, it's not 30 processes, it's 30 years, and many sectorial posters, fair salaries, no more pension fund administrators. So these are demands that are related to the reduction of the gaps. And these are inequalities, social, structural, gender, social class, ethnic groups, and we have a full array of demands, and this is seen in the public opinion. When you take a survey in the public opinion, you see that demands were heterogeneous, and as we had in Pulso Ciudadano, where we have pensions, inequality, crime, health, corruption, salary, education, justice, more or less with not uneven values. They had very high value. So, and this is, well, a political class that has no credibility, they need to solve these issues. So they have these in hands. So this takes us to the practical problems that we will be facing so as to solve these demands that are accumulated. In first place, we will be facing a political class, political actors that are called to model the expectations of the citizens with a low level of legitimacy. The largest political party in Chile uh, is the non and representation institutions and or no adhesion and some objective indicators and that show the deterioration. For instance, in Chile in the last 25 years, until the election of Michelle Bachelet experienced the second highest fall in the world in terms of electoral participation after Madagascar. So in this context where politics is important and where we need democracy, institutions, and actors, representative actors that would add up to these demands, these actors have a low level of legitimacy. And the second problem has to do in center left. Center left, we have seen independent candidates, and these sectors, they have pushed forward towards transformation. And with these high levels of fragmentation, it would be very difficult to build agreements. And the most conservative sectors, what they will be trying to do in a legitimate way is to keep the status quo. And this are tied up together. And we have over 40% of the conventional, and it has to do with the conservative sector. This could make it difficult. It could make it difficult. And lastly, and I would like to close with this, much of the demands, the social demands that have been accumulated, they have a structural character. We cannot solve these things overnight, issues of inequality overnight. These are problems that are embedded in the structure of the society. So even though we can write many things and paper can hold a lot, expectations might not be met at the end of the day. Thank you, Rosana. Thank you so much, especially for this yellow lights, these alerts that you are showing us of what's coming. Please please send your questions, your comments in the Zoom Q&A feature so we can come back and talk with our scholars about what you want to know. We have Janira Zúñiga, and she is a teacher of the public law in Austral University. She's a doctor in law in the University of Madrid, in Carlos III University, has made a postdoctorate in the Toulouse University, and right now is a pro-dean of the Juridical Sciences and Social Sciences of the Austral University in Chile. And she teaches pre-graduate and postgraduate subjects on human rights and gender. Has published many articles, collected books, national, international, in different news reviews and also in CONICET and magazines, and is part of the Consultant Council of the National Institute of Human Rights. Thank you, Yanira. The floor is yours. Thank you very much. I would like to start greeting everyone. Would like to thank you all for the everyone participating and being part of this forum of discussion. I don't think that I mainly disagree with the first intervention from Professor Brinks, but what I would like to do is to point out some issues, some shades of what we could extrapolate from what it has been said. We want to be open, we want to reformulate, we want to have constitutionalism and the categories, and that has implied a question. So how can law act as a catalyzing factor? And the question from the juridical environment, juridical and constitutional factor is not well considered. There is an excessive juridification. And what I mean with this term is that there is a trend to bring together the political, the juridical aspects. And I would add a third element to this melting pot. I would say that is the social variable from the point of view of the social actors, mobilization, social movements, and social needs that are behind all these movements and that are categorized as rights, but are resent to or reconsidered and read in a classic constitution that is individualist. So leaving aside all the other areas that are behind the construction or building up these rights. Dynamism and the phenomenon of constitutionalism, there is a certain rigidity within the constitutional studies so as to deal with these issues. And that would be my roadmap. I start with this, and we can summarize that in Chile, what is called the social unrest or social uprising, or what happened in October 2019, can be summarized into the full gap between reality and expectations. That is the experience, the what individually feel, what the individuals feel at an individual level and at a social level. So polarization, the capitalist polarization of the country has had a great influence in the increase of that gap, as Rosana was mentioning. But I would say that the way that I see this gap between experience and expectation is part of the modern constitutionalism. So it is a duality. It is a duality, and we have this as part of the paradox. It's part of the paradox, and it is a system that is creating expectations, and that rights take the expectations forward. This is part of dynamism of rights. So there is something of duality, and also in bringing forward an endemic attention of experience, expectation, and reality. And in the Chilean case, it is something that we have been studying. We have an acceleration that is produced by the predatory effects of a capitalist model, neoliberal vision, and this is what they say, this the cause of the social uprising. and also the causes and demands on the indigenous people. And it goes through a new wave in Chile and the world. We're seeing a rest, and there is an overlap, as Rosana was saying, the overlap of all the subjects and all the um, posters that she has seen. And in constitutions, they are in charge of offering and stabilizing with trying to align the social dynamism. And this is an obvious paradox. I wouldn't make this gap so dramatic, because we can understand this as part of the challenges that are changing, ever changing challenges, and that are challenges that are implicit in the model. So if we add that constitutionalism is facing, as many others are saying, is taking us to other challenges linked to the logics of overlapping and different pluralism, international, national, and pluralism derived from cultural reality, and the recognition of historical demands. Well, we have here the onset of pluralist democracy, with issues of identity and contemporary. So Chile is becoming part of that logic that has been developed in other countries. What I would like to point out, and in this last minute, is in feministic demand, would close this to open up the conversation.
I think it is important to observe that all the demands, as Rosana, these demands have a structural character with historical inequalities, and they assume or pre-assume an agenda of deconstruction that's important. On a good side of this structure, even all our structures of representation, gender parity is a discussion that is a quite clear sample on how you build the same model of representation that was used up to these days. But my sort of disagreement, and I will be closing with this, I don't think that the constitutional norm should be delinked of social. I think that the constitutional norm has a function in the social norm construction, which is symbolic. It's a symbolic function. Consequently, what I have seen, these expressions, they say aspirational, just to show the symbolic dimension as part of the juridical construction in their role of restructuring the social dynamics, which is not an immediate effect in the longevity horizon, but could influence in the long term decisively in the restructuring of social relationships by not thinking on the rights on the individualistic key, but instruments to provide not just the relationship between the state and people, but between the people themselves, which is also something that is the attempt of this logic. So my conclusion is, I think that we need to stop looking at the immediate inefficacy of these rights. What I'm referring to is the new rights of the Latin American constitutionalism or others that could be inserted in the feminist agenda that by definition will be an innovating agenda, like they are failure if we are really in a short-term, very narrow lens. Because from the social perspective, it's a more dynamic system. You recognize the agenda, you offer some input, and I agree with Dan that this will depend on, of course, on how strong is the judiciary branch in the institutional constitution. But what I mean is, it's not just um, a testimonial that, or uh, the dimension of perspective, not projective, in light of what the history of constitutionalism has provided And thank you, Sebastian, for giving me a little bit more time. Thank you, Yanira. Thank you for your words, especially for bringing to this uh, seminar the idea of the constitutionalism and the social issue, the social change, which is something that we should take care of. And eventually, in this first part, I would like to offer the floor to Marisol Peña, but remembering that you can ask your questions, as I said before, in Zoom. Marisol, she is the teacher of public law in Pontificia Universidad Católica de Chile, which is the place where she receives her bachelor's degree and studied in international relations in Universidad de Chile, being faculty member in the university in constitutional law and political law. She was a minister of the Constitutional Court between 2006 and 2018, and also chaired the Constitutional Court between 2013 and 2014. Marisol, it's a pleasure to have you here. You have the floor. Thank you, Sebastian, and good afternoon to you all. I would love to thank Rockefeller Center invitation and all the people who have been uh, trying to have this activity with this interest with we have reached. First, I'd like to say hello to the co-panel members with wonderful and provoking comments. It's so hard to say as the last one in the row to say something new, but I will try. I want to start saying that I cannot be more in agreement with Daniel in the sense that just the fact of providing new social rights or new uh, possibilities in the Constitution aiming to the equality of opportunities will be in itself a decisive factor in the change that Chile could experience in its society in the future. And I agree that also that answer could be negative. We could say that it is a coadjuvant element of that change we want to promote in Chile that clearly has been manifested by the citizens in the last plebiscite in October 25th last year when the majority voted in favor of designing a new constitution through the Constitutional Convention. And second, to also start mentioning that there are authors that make comparisons like Gerardo Pizzarello that place in the origin of the constitutional process in Latin America based in two factors, two type of factors, which are very much in coincidence with Dan Briggs' analysis. And the first is the lack of legitimacy that the leading elites experience manifested in all the surveys like Latino Barometro, Latin Barometer, where we see that there was lack of prestige in Congress uh, more and more increasingly, and the distrust of the citizens in the articulation of the interest of the democracy, like the political parties. But a second cause that Pizzarello includes that is also in the origin of the constitutional processes that we've lived and observed in Colombia, Ecuador, Bolivia, among others, has been certainly in the deep impact of the growingly inequality in the Latin American societies as a result of these leading elites and what they applied from their constitution, which was a logic that was related to a market policy that just created the possibility of deepening the gaps or inequalities. So then we ask ourselves, together with Dan, what is then the model of or the lesson from the constitutional side that we could take from that diagnosis that certainly I share, and it's applicable to the Chilean case. And I think that The first lesson to promote an effective change is to understand that we need in Chile a new model of democracy to supplement the representative classic democracy, and as Dan so well explained, not to reduce the citizen to being the executor of accountability or accountable for something that is sporadic in elections processes. There's something that is clear in social movements like the ones that Chile lived since October 2019 is that the citizens are complaining and claiming for more participation and involvement in the decisions that eventually will uh, affect their own fate. So it is something that unavoidable that I have to think that the problem solution for this constitutional problem we face now is not just more quantity of social rights in the Constitution, but also a democracy of a texture and quality that are different from what we have led so far and experienced so far to combine the classical elements of representation with more channels for democracy, participative democracy, or direct effect of the citizens. For political science experts, as Dan and Roseanne, that are so close to this idea in the political science world, the key is that Chile requires a constitutional change in which you assure a new governance model so the citizens will become, as the literature in the political sciences word says, we are partners of a state in the public decision process that could be coadjuvant for the decisions not to be that hierarchical or vertical from up to the bottom, but able to translate what the citizens really are requiring and need in the opportunities equality, which has been in the origin of the social change that Chile has claimed through manifestations and demands and needs that have been evident since October 2019. The evidence says that they claim transversally for more equality in the opportunities in all senses, not just impacting in the way we get the equality clauses in the Constitution, but we need to mention that these constitutions back in 1999 recognized the equality of all people, men and women, as a substance and the equality between men and women for rights. But we need more specifications on the equality clauses in gender equality, like you do it in the Ecuadorian constitution, establishing the main principle of equality in the salaries between men and women or remuneration when they have the same job assignment or responsibility. So we first face a revision of the constitutional clause of equality and maybe to a bigger precision of the interdiction clause for arbitrary situations. It's not then in a constitution that you will forbid discrimination, which is arbitrary, but we need to integrate these clauses with the interpretation elements that the constitutional jurisprudence all over the world has contributed to. And of course, the examination of the proportions to demand for the need of a difference, the inexistence of other possibilities for these differences, and the proportionality in justice specifically. But at the same time, I think that the social change that Chile demands, that should be triggered through this new constitution, demands by no doubt more commitment of the state in promoting and creating opportunity equality. So the debate on what is the formula of that subsidiary state, which is if it is or not the most appropriate as it was in the 1980s Constitution, if we maybe need a clause that is like the social state that many constitutions adopted to provide a powerful push for the state authorities to guarantee what Manuel Garcia Pelayo described so many years ago in Spain, which is the existential procure. There's no dignity if you cannot guarantee rights that are the supplement or what is the substance to develop your life. That's why Colombia developed this law concept to the minimum that is vital. And eventually, because of my professional background and the reflection of the judges that Dan mentioned, without prejudice of perfectionism that you could get in the new constitution on the DESC, social, economic, and cultural rights, there are some fundamental things that the Constitutional Convention will have to decide as the role of the judges. A constitution cannot place themselves in all the cases of differences and gaps that you have in the current situation that could happen in the future as we could rule for the present, but of course, thinking of the future, to the magistrates, they need the tools to develop justice. Some of these are the open clause of the human rights through which then you can apply justice of rights that are part of human dignity, even if they are not expressly mentioned in a constitution, like the Constitutional Court in Chile has done with the right to access of public information and the right to identity in some rulings, in which I was responsible and I feel proud of being part of the Constitutional Court when I was a member. And there's an important question that takes us back to the classic debate of what is the type of democracy we want. That debate between Jeremy Waldron and Donald Dworkin debate, a classic debate that is the solutions to inequalities will come exclusively from democratic deliberation that is verified normally in the parliament through the expression of the majority, and how the subsistence of disagreement that are not to be solved by the expression of the majorities could be channeled. We will trust that the resolution of the disagreement will be given to the judges. Then Dworkin comes saying, yes, but when disagreement is uh, doing something with public policies, then the judges can't come and they need to send that solution of this disagreement exclusively to public policy. Consequently, then I would say if the question for the debate is on this constitutional model, then there's a facing more power to the role of the magistrates and reinforcing the social rights, or establish constitutions like the Nepalese, Malaysian, and South Africa from 2006, some orientation principles for public policies where the co-legislature organs are the ones to be called, and then the traditional democracy principle. So you reserve some to avoid what happened in Colombia, which is the structural ruling that in a specific conflict in the constitution, they ended up deciding the course of the public policies that are fundamental for the life of the country. So thank you very much. I have learned so much today in this forum. Thank you very much, Marisol, for what you just said, for your comments, and for that view that you brought to this debate from our constitutional discussions that are the more daily ones, as you mentioned. So we think we already have one first approach to different perspectives for that question this forum called for. So I will now ask some of the questions provided by our uh, public, and you can continue during these 25 minutes. As I said, after that, we will invite the ones who want to stay to get into the Zoom and to stay on a more informal conversation if you want. There's a series of questions already arriving that will lead to a discussion on what comes next in the debate inside of the convention in itself and all that has been mentioned from the social claim and the open discussion that could be gathered and reinforced, channeled, etc. And Jennifer asks about the international treaty clauses and the clause that it's including in the constitutional reform that Daniel basically what mentioned is that the convention needs to respect and to be subject to the international treaties that are approved and are current. Or what Juan Pablo Rodriguez and Sergio Huerta say that is linked to the integration of that convention, integrating po- politicians or independent people or a mix, or a way in which this convention could process the social demands. This deliberation that comes that connects us with the next panel which this forum will have. But so far, we would love to hear what do you think in regards to the possibilities that are open, in regards to the risks that the convention faces with these special rules, and with the eventual integration of these 155 conventional members will bring, and the echo of what the citizens expect. These are ways to get different questions together, and we might start by Dan. So if you could freely react to what the others mention, or just face some of what I already mentioned. Dan?
Thank you, Sebastian. And thank you for all the participants for the questions. There are many, many interesting questions in the Q&A, and I hope I will be able to answer them. I will leave Roxana to predict who will be at the convention, but would like to know the effect on participation and inclusion, and what from that to the text and legitimacy. Because in a more empirical quantitative analysis of the constitutions around the world, is that a higher inclusion at the constitutional time, the greater length the constitution will have, the greater legitimacy that document will have. So therefore, it's important to have a high social participation in the constitutional process. I think Chile has done a lot. I think Chile has done a lot, and there are many, many processes that are, I guess, unique. And the question would be to which point people will feel represented in the Constitutional Assembly. And the question participation of political parties, elites, political elites, and including people, representatives from the citizens, the common citizens. It's time for representative democracy. It's not time for direct democracy and post direct democracy. So the document has to be produced with a legislative process, and there will be participation there. And the political parties, civil society, organized civil society. And what's important for me is that people should feel represented by the different elements that are there at the time of writing a new constitution. We also know that pluralism within the constitution, pluralism at the time of writing a new constitution takes most of the cases to a constitution that disaggregates power. It disseminates power and avoids concentration of power. So if you have more social elements represented, you will have a more representative justice and a more representative system. So it is important. So if there are different elements, visible elements in the Chilean politics within that constitutional meeting, well, it will be more legitimate with a greater acceptance, social acceptance, even though not all the points will be represented there, or whatever I want is not represented there. Now, regarding the actors, I am not clear about what that clause will have. In Latin America, there are many, many countries. In Argentina, 1994, and over that, the broad mass of it, and Constitution of Ecuador and Bolivia, they have done similar things. They have incorporated the international treaties. They give it a constitutional rank for international treaties and human rights and all other treaties adopted by the country. In general, as what Janita was saying, when you incorporate the rights, social, economic, and cultural, it is bringing in the whole meaning of those rights at an international level, as the Inter-American Court of Justice and other human rights courts, and is incorporating that meaning. For instance, the Constitutional Court in South Africa calls for international international law to make an interpretation. In Mexico, the Inter-American Court of Justice, they bring that in so they can do an interpretation of their constitution. So they have been building a regional constitution by importing decisions of different courts in the region. So to a certain degree, I would say that for more purist attorneys, this might be offensive, but there is a mix of compared law and international law. This is very difficult to bring them apart. So I don't know if there is an important difference there. I don't know if we say, okay, we adopt the right for healthcare, or we adopt an international ruling access to healthcare. Thank you, Daniel. We would offer the floor to Marisol now. Well, thank you. Thank you very much. And thank you for the person that asked the question. Regarding international treaties and the limits, which is in Article 135 for the work that the Constitutional Convention should work on, so as writing a proposal, and that will be taken to a referendum later and it has to be finally decided or approved by the community in Chile. Well, this might represent what we call a constitutionalism, multi-level constitutionalism, and this has been installed for a long time in constitutional doctrine that no constitution is capable of ensuring, holistically ensuring all those difficulties that arise from the human nature. And this is a constitution that complemented, and they since August 89, since uh, all the rights that are recognized in international law. So this is not something extraordinary out of the common reality, but we don't live in a polarized world. So we have multi-level complementary that deal with international law, international law regarding human rights. And something important in this question is the definition of the rank of the juridical rank of the international treaties that should be in the Constitution, because any litigator in Chile might ask, well, who should I be litigating against? Because if it's Supreme Court, the Supreme Court will be having a certain point of view. And they say international treaties will have the same rank as constitution. But if they go to constitutional court, they will make an interpretation and say that even though human rights, international treaties are below the Constitution. So we need to clarify that. We need to see how are we going to rank? How are we going to level? Because that is a certainty that we will have. Because even though Constitution will run short in terms of social, economic, and cultural rights, we will have a reinforcement, a complementary reinforcement of the international rights, international human rights that should be considered not only internationally, but on the criteria of interpretation in terms of progressiveness on social rights and progressiveness of other rights that are that need to be tackled by the courts today. Thank you very much. And thank you for the questions. I am not a political scientist, and I might not be the right person to talk about the projections, but I would say that the independent access is not only relevant or militants from the political campaigns, what has been done during elections, but considering my specialty area, how is it, how women, the presence of women will be and in relation with the critical mass, how critical mass is relevant, and also for the gender agenda. That's why this generates so much expectations, and things can run okay or maybe not so well. And how this experiment, which would be the first in writing a constitution, could offer or not all the other aspects that are necessary. So this is only one of the dimensions. It's only one of the dimensions if we're projecting these issues, and that the militant of the political party would be, this might be decisive in gender agenda. Well, in considering what we know and how this has been multiplied, social movements that are in more in participative democracy, not necessarily registered to any political party or belonging to a political party. And regarding the question from Jennifer, an Article 135 is curious to see. We interpret this, and Jennifer will know. Considering the discussion that it has been presented and with the clause, and also in the effect of limiting the subjects that could be discussed in the convention, and also with a limitation on the spectrum of that discussion. So what it has caused a constitutional discussion in Chile and also in an academic forum, and taking this to daily discussion, is the non-distinction of the clause between the international treaties on human rights and the international treaties that do not refer to human rights, specifically in the Chilean case, treaties, free trade agreements, and that would be a political focus in discussion, and the transformational agendas, especially with the point of view of restructuring, and also with the constitution and the discussion of strategic issues and the natural resources, not only water and all the other natural resources. And also important linked to important international agreements. So the question is, can we move forward in the restructuring and with other regimes? Question: how economic treaties could reduce the agenda, recognition of social rights, cultural rights, and economic rights? Thank you. Thank you, Yanira. To close now, Rosana. Well, with Jenny's question, I will not answer it because I think it was an exceptional question, and I'm not an attorney, so I shouldn't answer it. But the other question that was sent to me is that sometimes you begin with these presentations, you say, well, this is a complex issue, we don't have enough information, there is a lot of uncertainty, and this time is true. This time is true. We're in a unique process. We have a full array of candidates, many candidates, and the only thing that we are certain of is that we will have gender parity, and we have 17 positions for our First Nations. And I would say that, and I could say that what experts have said about that. So I will blame my colleagues, because if what I'm saying here is not true, at the end of the day, we could say my colleagues told me. So the most recent survey that I saw is a survey from La Tercera newspaper, and this process will favor conservative sectors, and they're well considered, well coordinated, and together, working together. So all the dispersion, all the candidacies that we had, and central left, it wasn't so positive, so it tilted towards the right. Now, in this survey from La Tercera newspaper, they said that with the agreement of the right sector is 40% of these seats will be taken by that bloc. And then the others will be distributed in a variable way PS, PP, PC, and Pro as a central left bloc, it would be a third of the seats, and then PC bloc, regionalist bloc, democratic revolution, and that would leave out the independent. This is a scenario, and it is a scenario that is not so pro-right. And we have a number of variations. Projections, and the most generous to independent, they give it a 20%. Those that think that independent do have a chance to go in, do have a chance to get seats, and they say maximum 20%. So this is what I could do, or what I could say rather. And in terms of projections, these are colleagues that are experts, and that is between 30 and 45% is for the right. So what we could expect is that political parties will have a strong presence, and that the independent sectors will have less presence, and they will have, at the end of the day, results that will favor conservative sectors. Thank you. Thank you, Rosana. I would like to conclude that, well, there are other questions, and we won't have an additional round, but as I mentioned, those that could stay, we will allow them to come into the Zoom, and we will have a brief conversation, an informal conversation. I would like to thank you all for those participating on the questions, and we have talked about law, public policies, democracy, representation, the role of the Constitution, and that will allow us to put light on our debate, things that we will be talking about in the following months. I would like to thank everyone for the opportunity they gave me to be the moderator of the panel, and would like to thank and offer the floor to Steve so we can close this stage and open up the Zoom so we can all start chatting. I would also like to say that next session will be May 7th. May 7th, and it is on international perspective on the rules of the game, and all the things that matter. I hope we can meet again there. We will now go to an informal part. I was trying to see if we need to do something so we can bring everyone in with our